case briefs, and so much more. LSData's got what you're looking for.
In 2008, the Florida Supreme Court heard Walton County v. Stop the Beach Renourishment, Inc., a case centered on the state's responsibility to protect beaches and hold lands under navigable waters in trust for public use. The Beach and Shore Preservation Act was created to help restore eroded beaches and establish the boundary between public lands and private uplands at the mean high water line. The act also allows the state to reimburse up to 75% of actual expenses for rebuilding and renourishing critically eroded coasts, while providing upland owners with commons rights to bathe, fish, and navigate, as well as special common law littoral rights. Stop the Beach Renourishment, Inc. challenged the constitutionality of the act, arguing that it unlawfully deprived them of their riparian rights. The First District Court of Appeals certified the question for review as to whether the act has been unconstitutionally applied. The case was then brought to the Florida Supreme Court, which rephrased the question as a facial challenge and ultimately found that the act does not unconstitutionally deprive upland owners of littoral rights without sufficient compensation in the context of restoring critically eroded beaches. The court held that the Beach and Shore Preservation Act is constitutional, allowing the state to restore storm-damaged shoreline by adding sand to submerged sovereignty lands. The act balanced public and private interests, shifted the risk of loss and repair from upland owners to the state, and set boundaries while preserving littoral rights without violating the Constitution.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.